Thank you all for coming. We're going to go ahead and get started. I know almost all of you. I'm Jean Sternlight, Director of the Saltman Center for Conflict Resolution, and thank you for coming to one of our regular events. We hope you enjoy it. Today we're really privileged to have here Professor David Spencer, who comes from the other side of the world, as you'll soon hear from his accent. He's an Australian, and I could try to pronounce that in an Australian way, but I would fail. I met David at a conference. It was probably, 4 or 5 years ago now. We were at a conference of the American Bar Association section on dispute resolution, which a number of lawyers from other countries have now chosen to attend because it has quite good programming in the area. And luckily for me, David was attending there. And I really can't even remember exactly why we started chatting or what it was about, but we became colleagues from different countries as a result of having met there, and we've had a really useful and interesting exchange over the last few years. So I was really delighted when David, as a result of having won a teaching award in Australia, decided that he wanted to come here to Las Vegas to learn a bit about how we teach law school and how we teach dispute resolution, and also a little bit on the side. Check out Las Vegas, I'm sure. But as part of that, he agreed to come give a talk. And David is really an expert on ADR in Australia. He's written several books, and I have them up in my office if any of you want to see them. I think his most recent one is published with Cambridge University Press, which is, of course, a very, very well-known publisher, and the others are published as well with very well-known publishers. And he's written on a variety of aspects of dispute resolution. He covers a broad sort of territory when he focuses on ADR, so he doesn't focus exclusively on negotiation or mediation or arbitration, but rather has written on all of them. He's written a lot of articles. His other field of expertise is contract law. So I think it was a good choice of his of the topic that he's today addressing a confluence between ADR and contract law and talking about enforceability of dispute resolution clauses in Australia. He's currently at a place in Australia in Sydney called Macquarie University, and he's soon to be moving to another university, which I've forgotten what the name of it was. La Trobe University, which is in Melbourne. So should any of you make it to Australia in the next few years, you'll know where to look for David, and I'm sure he'll be a wonderful host. With no further ado, David Spencer, if you would come and give your talk, we'd be delighted. Thank you. Oh, and there are handouts. If you didn't get a handout and would like it, there are some around the room. And okay, great.
Oh, thank you for that introduction. And, ladies and gentlemen, colleagues, thank you for spending your lunchtime with me today. I want to start by perhaps telling you a true story. At a social event one Saturday evening, there was a surgeon, an engineer, and a lawyer that got talking. And somehow the conversation drifted towards who had the oldest profession. And the surgeon piped up first and said, well, I can sort this out very, very quickly. You will recall from your Bible that the Lord took a rib from Adam, created Eve, and the human race started. So therefore, medicine is clearly the oldest profession. And the engineer said, well, hang on a minute, wait. If you're going to throw the Bible at us, you'll also recall that from the chaos and the confusion, the Lord created the heaven and the earth in 6 days and rested on the seventh. So therefore, engineering is clearly the oldest profession. And the lawyer laughed in a maniacal way and said, who do you think created the chaos and the confusion? Well, certainly in Australia, this issue of the enforceability of dispute resolution clauses is in a state of chaos and confusion. But before I get into the actual substance of what I'm speaking about today, I thought I'd better just give you a very, very quick rundown jurisdictionally what happens in Australia so that some of the things I say today will be in the correct context. And I might warn you that there's a very quick pop quiz coming at the end of this, and there's a prize too attached to it. This is a very poorly handcrafted map of Australia. We have several different states and 2 territories, and the territories were created by our constitution more than 100 years ago, and the Commonwealth government, the federal government, has jurisdiction largely over those 2 territories. But other than that, the states themselves have a lot of power, and the deal was at federation back in 1900 that they retain a lot of those powers and only give up certain powers to the national government, the federal government. In terms of the courts, I've simplified this a little bit, but in each state and territory there are 3 levels of courts, starting from the bottom, the local court, the district court, and then the Supreme Court. And in civil matters, obviously, the amount of money that you can claim in each court goes up to an unlimited amount in the Supreme Court of each state and territory. Above that, of course, they all have a Court of Appeal, which is the highest court within each state and territory. Now, federally or nationally, we have a federal court, we have a family court, and we have the High Court of Australia. And that's the equivalent of your Supreme Court. It's the highest appellate court in the country, and any appeals from state courts of appeal will find their way into the High Court of Australia. Well, if you're lucky, only about 5% of leave applications at the moment are getting up in the High Court because they are so busy. And the cost of lodging a leave application is about 40,000 Australian dollars. So you've got to have the money and you've got to have a very good reason to get yourself in front of the High Court these days. So that's a quick rundown of jurisdictionally how we operate in Australia. Here's the pop quiz. And Elaine, you are precluded from answering this because you had a sabbatical in Australia, and Steve, you're from Australia, so you're precluded. This is called a level playing field. I'm going to ask you this question. First person in wins the prize. What is the capital of Australia? Yeah.
Canberra.
Well done, yes. Okay. Canberra, which sits in the Australian Capital Territory, a territory created really to house the federal parliament and to manage nationally what happens in the country. Now, the prize is a genuine Australian chocolate bar. Just ignore the fact that it says made in the United States on the back, all right? This chocolate bar has come a long way to be here today, so you are the winner. Well done. I'll just park that up. Well done. All right, let's get started on this issue of the enforceability of dispute resolution clauses in Australia. It is a bit of a mess at the moment, thankfully, because it gives me something to write on. The situation in Australia is that when parties contract privately and they include in their contract a clause that says before either of us can head off to court, we must participate in a dispute resolution process. The situation is that no judge in Australia has seen fit to enforce such a clause. They have done it what I call the backdoor method, or they've done it by stealth. They have on a couple of occasions allowed what we call a stay of proceedings, in other words, holding off the court proceedings to allow the parties to participate in the dispute resolution process. But no judge has come out and said, you breached the clause, here's the bucket of money and damages, or here is an order for specific performance of the contract. No judge has done that. So we have a situation where these clauses, and they are in just about every single contract nowadays in Australia, not only building and construction matters, industrial relations type contracts, all manner of contracts have dispute resolution clauses in them now. The penetration of these clauses is enormous in Australia, but not one judge has seen fit to enforce any of these clauses, other than this backdoor method of ordering a stay of proceedings to allow the parties to go away and do what they said they would do, and that is perform a dispute resolution function. There's 4 reasons. There's 4 reasons why judges will not enforce dispute resolution clauses in Australian contracts, and there they are. Firstly, they are not, if they are not drafted as a condition precedent, then the court will immediately bounce them out. Secondly, they have a great deal of difficulty with the certainty of these clauses, and that's a construction issue of the contract itself. Thirdly, most of our clauses have a reference to good faith negotiation, mainly because there's a statutory requirement in court annexed dispute resolution processes that the parties participate in good faith. But in private contracts, the courts have a great deal of difficulty in enforcing that sort of a requirement, and I'll get to that shortly in terms of the reasons why. And finally, they lack an adequate remedy for breach. courts have been very, very nervous about saying, well, okay, we realise that you haven't done what you said you were going to do, but how do we come up with some sort of remedy that's going to fit the bill over that breach of contract? And again, I'll get to that shortly. So they're the 4 reasons. Let me try and take those apart for you as best I can over the time we have together today, and ensure that you have some understanding of why the courts have been very reticent to enforce these sorts of clauses.
David, I have a quick, just the definitional question. When you talk about dispute resolution clauses, are you talking also about arbitration clauses or just negotiation and mediation?
Yeah, good question. I perhaps should have made that clear up front. No, we're not talking about arbitration clauses, and the reason being that that is governed by statute in Australia, and the law is very well settled that the interpretation of the statute is as it's written, that if you agree to arbitrate, then the courts will enforce that under the statute. So yeah, we're not talking about arbitration, we're mainly talking about mediation and conciliation processes. All right, well look, let's deal with the first one because it's a bit of a no-brainer, I think. There's a very old English case by the name of Scott and Avery that determined that parties in a common law system can't oust the jurisdiction of the court. You can't agree not to litigate. It's your right to have your day in court, and no contract can get you out of that right. And so our clauses in Australia tend to reflect, and I've given you one on your overhead there, and here it is on the screen, a clause that the New South Wales Law Society recommends for contracts. And I don't want to read it, you've got it there in your handout, but you'll see that it makes the dispute resolution process a condition precedent to litigation. So that's fine, providing we say, hey, you've got a hurdle to jump over before you get into the court, that's okay. What we can't do is say you can't go to court. So making the dispute resolution process a hurdle is quite fine, providing we don't oust the jurisdiction of the court. Well, that's an easy construction issue that lawyers drafting contracts in Australia have found very, very easy to overcome, even if they don't use the standard precedent provided by the Law Society. The next 3 issues are really the interesting issues. Starting off with this issue of a lack of certainty as to the construction of the term. What I've got up there for you is the definition of certainty in contract law provided by 2 of Australia's more eminent contract law scholars. And I note in your restatement second on contracts that you similarly have a similar doctrine of certainty, and that is that when you're drafting a contract, you've got to make sure that the parties know what they're getting themselves in for. You've got to make sure that the parties are able to clearly perform the contract, and the words of the contract are material, of course, when it comes time to perform the contract. And so this particular definition, I think, just reflects that. It says that, look, if you're drafting a contract, the language has to be clear. The parties have to know exactly what it is that they are expected to do under the contract in order to perform the contract through to discharge. Now, the fascinating thing in Australia is that the state courts, in particular the Supreme Court and the High Court of Australia, have read the certainty rule very differently. The High Court of Australia has read the rule what I would call fairly broadly. Let me perhaps give you an example. A contract between 2 parties over a lease. It doesn't matter whether it's a commercial or a domestic lease, let's just say it's a commercial lease. That sort of a contract, at least at the formative stages of development, let's say it's a heads of agreement between the parties to ultimately enter a contract, the High Court of Australia will enforce a contract that says that you and I agree that we will lease this property for 5 years at X rent on the usual terms of a commercial lease. Now, in terms of certainty, that's problematic. We don't know the exact terms of the usual terms of a commercial lease. But the High Court have read the rule fairly broadly, and they've said, look, objectively, we can determine what the usual terms of a commercial lease are. There's thousands of them entered into every week in Australia. Sure, they may differ in some respects, but we know that objectively, we know what sort of terms exist between parties in these sorts of relationships, and we're happy to read that to have the requisite certainty and allow the parties to move forward and perform the contract. However, in the states, in particular the state of New South Wales, the Supreme Court has rejected that idea. The Supreme Court of New South Wales has on many occasions said, sorry, that's not good enough. We need the exact terms in the contract between the parties so that they know what they're getting themselves into. We won't allow the parties to walk away not knowing what the exact terms of the contract is in terms of the rights they're giving up, the liabilities that they're incurring through entering into the contract. Now, in terms of dispute resolution, these dispute resolution clauses, that raises a very interesting issue, because a dispute resolution clause generally states, well look, if there's a dispute that arises out of the contract, parties will participate in mediation before they go to court. Well, from a certainty perspective, what does that mean? What are the steps of mediation? What is mediation? What is conciliation? What is negotiation? What are the steps that you have to take to be able to satisfactorily perform that term of the contract? Now, I'll get to New South Wales in a little bit more detail in a moment. In Victoria, we have an enlightened judge, one judge on the Supreme Court that handed down a very important decision 80 years ago. And the surprise is here that it's a female judge, being the enlightened judge. And I say no surprise because, as we know, the genders tend to negotiate and see life in a different way. And this particular judge has taken a contrary view to most of her male colleagues, and certainly the New South Wales bench in its entirety just about. And she said this. She said, look, this thing, dispute resolution, this thing has many different manifestations. And here's the beauty of dispute resolution. It's largely driven by the parties. So therefore, do we need to see, clause after clause after clause in a contract setting out the steps of the dispute resolution process? Well, no. That defeats the purpose of dispute resolution. We shouldn't need to see that in the contract. We should just be able to say, look, if you've agreed to mediate before litigation, just go and do it, will you? How you do it is to a certain extent up to you, because that's the freedom of dispute resolution, that's the elegance of dispute resolution, that you can do it in any way you want to do it. It's driven by the parties themselves. So let's let the parties just go on and do it in whatever manifestation they feel is appropriate, and we will enforce those clauses and make them do it. Well, it's a radical view in Australia, and it's a good view, but of course it's a view that to date hasn't been taken up, certainly by the New South Wales Supreme Court and any other state Supreme Court. I should have mentioned at the beginning, and it's probably important to mention it now, that this issue really has only been addressed in the state of New South Wales and to a lesser extent in Victoria. None of the other states or territories have yet had to pronounce on this particular issue. And of course everybody, I suppose, is watching New South Wales in particular to see what is going to happen over the next few years. And of course we are anticipating and we hope that there will be a decision come out of the High Court at some stage soon that will give us a definitive answer. But anyway, that's why we're in a state of chaos and confusion at the moment. Let me talk about a couple of cases that hopefully will settle this in context and give you a bit of an insight into why the courts have found the way they have on this particular issue. This first case is a very important case and really was was the first decision in New South Wales to address the issue. And it's kind of an interesting case because we have a new Parliament House in Canberra in Australia that was opened, more than 10 years ago, 15 years ago, 20 years ago. Yeah, 20 years ago. Steve, help me out here. When was it opened? Wasn't it for the bicentenary in 88? Yeah, 20 years ago. And this thing is a piece of beauty. They created a mountain to build the Parliament House in. Billions of dollars it cost to build this magnificent Parliament House that will last us now for probably 100 years or more. This case is about the installation of the drywalls in that Parliament House, and that's why it's a kind of an interesting case. What happened was, and I won't go through all the facts in detail, but take it from me that a dispute arose between the parties, the head contractor and the subcontractor providing the drywalls in the new Parliament House. What they agreed upon, once the dispute arose, was that they would conciliate the dispute, any dispute that arose. Now, we need to be a bit careful here because there wasn't a dispute resolution clause in the contracts between the parties. They agreed after the dispute arose that they ought to have a go at trying to conciliate the dispute before heading off into court. You can imagine how long it would have taken to get this matter through the courts and the costs. It was a huge, huge contract, multi-millions of dollars. This was the substance of the letter that I've got up before you, and this is material when we start comparing it with some other cases that have created doubt over the enforcement of dispute resolution clauses in Australia. So there was a bit of correspondence that went between the two lawyers, and this was largely the substance of the letter. The letter said, or set out, who the mediator should be. It set out the issues that were there for conciliation. It set out that there would be no lawyers involved. It set out some details on the rules of evidence, the fact that there wouldn't be a transcript, the fact that there would be oral evidence with questioning, the fact that there would be a written summary to the conciliator, the fact that there would only be 2 spokespeople for each party, the fact that there were to be no more than 2 qualified experts to give evidence, and the fact that there would be rulings and determinations on each issue made by the conciliators. This is a letter that went between the 2 lawyers. Now the court, when this eventually got to court on the basis of enforcing the conciliation process that had been agreed upon, when it got to court, the court said that, well, look, we think there's enough certainty in the letter between the 2 lawyers to allow us to, say to the parties that you ought to go ahead and conciliate this matter before you head off into court. Again, they did it the backdoor method. They only did it by a stay of proceedings. They said to the parties, we're going to hold this matter over for 3 or 4 months. You need to go out and you need to get this conciliated. Then you can come back to the court and we'll see what happened. But the most important thing about the judgment is that the court found that it contained the requisite certainty to ultimately enforce the letter between the parties as a term of a contract. Interestingly, they said that the stay of proceedings was based on an abusive process or avoiding an abusive process. That is, if the court didn't force them to conciliate, it would be an abuse of the court's process to allow them to jump straight into litigation. An interesting piece of reasoning, despite the fact that the judge didn't technically enforce the clause. Well, life for contract lawyers became a little bit interesting at that point in time, and it was, of course, during this point in time that the rise of dispute resolution clauses going into contracts was occurring, and everybody jumped on the bandwagon and started putting dispute resolution clauses into their contracts. The next case came along about 5 years later. An important decision, this case of Elizabeth Bay Developments against Boral Building Services. Again, I won't go into the details. It was a building and construction contract. There were management and construction contracts between the parties. A dispute arose. There was a dispute resolution clause in the contract. Now, here's the interesting thing about this particular case. There were 3 documents at play here that the court had to consider. The first document, of course, were the contracts between the parties that contained the dispute resolution clause. Now, those clauses made reference to guidelines from the Australian Commercial Dispute Centre, which was a government-funded centre that provided dispute resolution services and tried to sort of spread the word amongst the commercial community about dispute resolution. And they also set up a case management system where you could ring them if you had a dispute with another party, and they would take the case on, organise the other party, organise the rooms, help you select a mediator or a conciliator or an arbitrator for that matter, and just help manage the whole process. So the dispute resolution clause referred to the Australian Commercial Dispute Centre guidelines, another document that they produced that explained the whole process to parties and what they had to do. So the clause mentioned the guidelines. The guidelines mentioned the appointment agreement. And as most of you I'm sure are aware, mediators these days, or conciliators, even arbitrators, enter an agreement with the parties, mainly to cover their fees, but also to cover other administrative things between the parties and to make sure that everybody's clear on what's going to happen. So these guidelines referred to that third document, the fact that the parties would be asked to sign this mediation appointment agreement to engage the mediator. Now, the defendant in this case, the court said rather stupidly, but anyway, the defendant made the concession that all three documents were one. So in other words, they conceded that all three documents formed the contract between the parties. So automatically, all those terms and all those three documents become the agreement between the parties. The judge said it was a rather stupid concession because it would have been much easier if that concession hadn't been made, and it would have been a matter of saying, well, the original contract lacked certainty to be enforced, and that would be the end of the matter. But now that you've agreed that all these documents form one contract, we've now got to go through and look at all the terms in all the documents to see if they can be enforced. So the court embarked upon that sort of an analysis, looking at each of the terms in the three documents that formed one contract to see whether it was able to be enforced. Now, juxtapose this with that previous case. That previous case had one letter between two lawyers setting out 10 terms, and the judge found that letter was certain enough. Well, surprise, surprise, the judge in this case says, sorry, these three documents aren't enough. It's uncertain. It is going to be void for uncertainty. You are not bound to participate in the dispute resolution process. So we had a volume of documents versus one letter, and a very, very strange result. Here's some of the rationale for why the judge found that those three documents together were still uncertain. Firstly, one document said there could be representatives for the parties, that is, their lawyers present during the mediation process. The other document said, no, you can't have representation. One document said that there had to be a statement to the mediator on important issues. The other document said there had to be a statement to the mediator on the nature of the dispute. I'm not sure what the difference between those two things are. They sound pretty similar to me, but here's a judge in the Supreme Court saying, well, no, those two things mean different things, and therefore the documents are uncertain. Another one was that one required the execution of a confidentiality agreement, the other one didn't. One spoke about the procedures of mediation and the other one didn't. And one spoke about the requirements for terminating the mediation, the other one didn't. So the judge found enough difference between the appointment agreement and the guidelines to say, sorry, we can't enforce this dispute resolution clause. Well, along comes the third case, and the last one I'll mention. This most important decision of 8 in Australia, a 1999 decision followed 4 years after that Elizabeth Bay decision. And here we had a detailed dispute resolution clause. Believe me, this clause had just about everything in it. Yeah.
I have a question about the previous case. That when the appointment letter, was that something that was, or the appointment agreement with the mediator, was that drafted at the time the contract was drafted, or was that just mentioned and it was actually drafted later?
Technically, it was drafted before the contract because it was a document supplied by the Australian Commercial Dispute Centre, that is the administrators of the dispute once the parties brought the dispute to them. So technically it was drafted, but the parties hadn't seen it because they didn't know a dispute was going to arise under the contract.
Right, that's what I think it would be strange to appoint a mediator for a prospective dispute.
Yeah. And look, I think if we look at the pure doctrine of uncertainty, even as it unfolds in your restatement document, I think the judge was probably right. It just sounds absurd that we had 3 bits of documentation that really set out a lot of detail on how mediation was to run. That was deemed to be uncertain versus a letter with 10 points in it between 2 lawyers. in the Hooper Bailey case. It's kind of hard to reconcile the two cases, but I think, purely on a doctrinal reading of the uncertainty rule, the judge was probably right. There probably were too many inconsistencies, and the point you're raising, I think, is that the parties hadn't seen the document when they entered the contract, and on that basis, it's very hard to bind them to a document that they haven't even seen. So I think the judge was probably right in that respect. Does that answer your question?
Yeah, so it goes back to what you said, that decision that all the documents merged was what created the ability to even argue if there was certainty.
That's right, yeah. If they hadn't made that concession, the case would have been over in 5 minutes flat. The judge would have said, sorry, there's not enough detail here in the contract alone. Forget those other 2 documents, you're out of court, get lost, or come back when you want to litigate. Agent Australia, again, I won't go into all the details, but there was a very detailed dispute resolution clause in the contract. And you're going to love this after these 2 previous cases. The judge bounces the parties out of the court. The judge says, no, this dispute resolution clause is void for uncertainty. You cannot enforce it on the basis that the dispute resolution clause didn't set out the apportionment of the mediator's fee to be paid by the parties. How's that for a narrow reading of a rule? So it set out everything else. It set out how much the mediator was going to be paid, who was to appoint the mediator, all the steps in the process, but it just missed that little point about who was going to pay the mediator's costs. And of course, customarily, as we know, it's usually, well, in Australia, it's usually 50-50. The parties pay 50-50 costs of the mediator. But that detail wasn't in the dispute resolution clause. The judge says, sorry, you're out of court, void for uncertainty. So you can see that there's been a rather bizarre application of this rule of uncertainty. The judges are really picking up on some very, very minute points to get these clauses, to get the parties back out of court, back in when they want to litigate, and not enforcing the clause, which is a little bit of a problem. So, a straight reading of the certainty rule, the certainty doctrine, has allowed the New South Wales Supreme Court not to enforce any of these clauses. So that's the second big problem that we have in Australia about dispute resolution clauses. The third one is this issue of good faith. And most of these clauses had a good faith requirement in them. They said that the parties, were bound by contract to participate in the dispute resolution process in good faith, to do the right thing and participate in a fair way. Well, what does it mean? What does this reference to good faith negotiation in the performance of a contract mean? Well, for starters, the courts have again picked on the certainty issue as a way to not enforce dispute resolution clauses in contract that make reference to good faith. Well, here's what it meant to the judge in that Elizabeth Bay case that I mentioned before. The judge pointed out that the difficulty lies not so much in the ascertainment of the presence or the absence of good faith. So in other words, the judge is saying, hey, we've got no problem identifying what good faith is. That's not the issue here. It's the next bit that's the issue. The necessary tension between negotiation, in which a party is free to and may be expected to have regard to self-interest rather than the interests of the other party and the maintenance of good faith. So what the judge is saying here is this. You can't enter a negotiation, mediation, conciliation in good faith and still preserve self-interest. Think about it in this way. When a dispute arises under a contract, the parties will generally act with self-interest, and it's their right to do so. It's their absolute right to do so. The judge is saying that you can't conduct the dispute in self-interest and at the same time maintain good faith negotiation or mediation or conciliation. The two just don't sit together. You can't do it. And so on that basis, the judge said in this particular case that the clause once again must be uncertain because you can't reconcile those two requirements in a contract. You just can't do it. Well, in 1995, and I was intimately involved in this particular case, in 1995 the world became a little more straightforward to the drafters of contracts that wanted to include dispute resolution clauses in Australia. All we did was take out the good faith reference. It was nice and simple. However, life only remained simple for a few years, because coming on its heels 4 years later, this Ayton Australia against Transfield case that I mentioned before came along, and the judge decided to disagree with the previous judge in the Elizabeth Bay case on this reconciling good faith with self-interest. And here's what he said, a little bit from the judgment. I disagree with Justice Giles, who was the judge in the previous case, that Elizabeth Bay case. Such tension ought not to be the linchpin in an argument that a good faith requirement in negotiation is too vague and uncertain to be meaningfully enforced. Maintenance of good faith in a negotiating process is not inconsistent with having regard to self-interest. So he's saying the other judge just got it wrong. You can preserve your self-interest and act in good faith at the same time in a dispute resolution process. As long as you're forthright, you're honest, you can go into a negotiation and say, look, I've done everything you want me to do. I've turned up on the right dates. I've addressed my mind, to what the issues are. I've tried to engage with you in the negotiation or the mediation or the conciliation. I've done my best up until this point. But out of self-interest, I cannot agree to the settlement that's being proposed. I just cannot do it. It doesn't do for me what I need to have done in respect of the outcome of the dispute. So it is possible to maintain your self-interest and to act in good faith. And that was the proposition that this fabulously named judge, Justice Einstein, put to the court in that particular case. The previous judge got it wrong. Yes, you can participate in dispute resolution processes in good faith whilst at the same time preserving your self-interest. Well, that has led a number of commentators, including myself, to start thinking about, well, what do we mean by good faith? What do we mean by good faith negotiation in a dispute resolution clause or indeed under statute? We need to take a whistle stop over in England, because the judge in the Elizabeth Bay case that first rejected this idea of being able to negotiate in good faith whilst preserving self-interest relied wholly on a landmark decision out of the House of Lords, in that case of Walford and Miles. And in Walford and Miles, the House of Lords made it absolutely clear that, again, this whole concept of negotiating in good faith and at the same time preserving self-interest was repugnant to the adversarial system itself. And again, I go back to that starting point on this particular third issue, that you simply cannot enter a negotiation in good faith once there's been a breach of contract. You are entitled to preserve your self-interest. You're entitled to negotiate on the basis of your self-interest. You don't owe the other side anything. That's what the adversarial system is about. I think the judge got a little bit confused about the difference between the adversarial system and negotiation and mediation, but hey, this is the House of Lords. We don't argue with those sorts of people. But that's what the judge said. We are operating, once a dispute arises under the contract, we are operating in an adversarial system. And you can forget about entering a room in good faith and throwing your self-interest out the door. That doesn't happen, and neither should it happen. You've got the right to preserve your self-interest. So the Australian judge in the Elizabeth Bay case basically used Walford and Miles as the rationale for finding that the dispute resolution clause couldn't be enforced because it mentioned good faith. Well, what does good faith negotiation mean outside of England? Well, I'm being very brave here, and I'm going to talk about the United States, even though I'm in a room of eminent scholars and learned students who probably know more about the American situation than I do. If I say anything wrong, feel free to throw something at me. Literally, not done. We've looked at a number of areas in Australia to try and make the comparison, to try and find out, well, what does this thing mean? Can you preserve self-interest and negotiate in good faith at the same time, therefore making those clauses enforceable? A number of us have looked at the National Labour Relations Act, which is a pretty important piece of legislation, I gather, in this country. And we've looked at what that particular act defines good faith negotiation as, and we have come up with the fact that it probably means that you need to enter the negotiations with an open and fair mind. That's the simplistic version of it. The cases that I have noted that have come out of the National Labour Relations Act show that the courts in the United States tend to take the view that honest and sincere bargaining does not require parties to settle, and it doesn't require parties to make concessions necessarily. Again, it takes the approach, quite logically, that you can enter the negotiation, and providing you act in a honest and fair and open-minded way, you've satisfied the requirements of good faith. You are not required to settle under a good faith requirement. Your chief civil code in the United States, the Uniform Commercial Code, UCC, I note it contains 9 articles, and in those 9 articles there are some 400 sections, and in 6 of the 9 articles there's actually a statutory definition of good faith, and it tends to mean honesty in fact and the observance of reasonable commercial standards of fair dealing. Again, nothing about having to make concessions, nothing about having to forfeit self-interest, nothing about having to settle, no mandatory requirement to settle to satisfy these good faith requirements. A couple of, I would say, from my readings, eminent professors in this country on contract law, Professor Robert Summers, who the articles that I read was based at the University of Oregon, I'm sure that he still is, rejects the idea of a statutory definition of good faith. And he says that, look, good faith is a concept that is circumstance bound. It is circumstance bound. The courts need to address whether parties have acted in good faith based on the merits of each case. You can't come up with some sort of blanket definition that is going to satisfy everyone. He came up with something called his excluder theory, which seeks to identify bad faith and then comes up with a definition of good faith effectively as an opposite of what the bad faith behaviour was of the parties. A Professor Stephen Burton at the time I read these articles was at the University of Iowa, who has been a bit of a critic of Professor Summers, I gather, although agrees with Professor Summers that a statutory definition is inappropriate. It puts you too much inside a box and doesn't allow you to move given the circumstances between the parties, particularly when it comes to good faith negotiation. And he developed this recapture theory, which I think was quite an elegant theory, that when you agree to contract with somebody, you give up certain opportunities. And then if you breach that contract, you're seeking to recapture those lost opportunities. But most importantly, he suggests that we use an objective test to identify the foregone opportunity and a subjective test to determine whether a party used its discretion to recapture the foregone opportunity and therefore be able to assess whether the party's behaviour was in good faith or not. So a couple of interesting theorists there. There are other theorists here in the United States, and time is going to kill me this morning, so I perhaps won't go into those, but Professor Alan Farnsworth and Professor Lucy Katz have also had quite a bit to say on how we define good faith. But here's the most important thing that I have gleaned from the American scholars on this issue, and that is that nobody suggests that you have to forfeit self-interest to be able to negotiate in good faith. And we need that sort of input in Australia when, once again, it comes time to trying to define what good faith negotiation means in these contractual clauses. Well, where are we in Australia then? Time is going to beat me, so I won't go into a lot of detail here. But we have had a number of judges and a number of commentators consider the issues since these cases. And most of them now tend to agree that, well, yes, doesn't matter whether it's a contractual provision or a statutory provision, we don't need to be able to, we don't have to say that in order to negotiate in good faith, you need to forfeit self-interest. You're entitled to walk into any dispute resolution process, and providing you act in an appropriate way, you don't have to forfeit your self-interest in order to come up with an outcome between the parties in the process. Why is this important in terms of contract law? Well, it's important for a number of reasons. Firstly, there's the whole issue of enforcing terms between parties. I mean, that's obvious as the nose on your face. But the other important issue is that, as I mentioned at the beginning, we have a statutory requirement in Australia for good faith participation in court-annexed dispute resolution processes. And as of today's date, I'm pretty sure, even though I've been here in the United States since Sunday, nobody has ever challenged that statutory requirement. But the day is coming soon when it's going to happen. And unless we have a decent definition in place, again, we're going to relive the mess of case law that has already evolved when it comes time to determining whether somebody could effectively be prosecuted under the statute, and I say prosecuted in the civil sense, prosecuted under the statute for a breach of the good faith requirement. So for Australia, this is quite a key question in relation to how dispute resolution is going to unfold in the future in this country. So we are up in the air. We are up in the air. Sir Lawrence Street, a former Chief Justice of New South Wales and probably Australia's most well-known mediator, a QC and a Knight of Her Majesty, has suggested that we just omit references to good faith negotiation in our contracts because, in his words, it's not worth the fight. And it's certainly, as a lawyer, it is not worth subjecting your client to the possibility that there could be a successful challenge on the validity of the dispute resolution clause in the contract and have your client only have litigation as the way to resolve the dispute. And that's the situation that we're in. The fourth area that we have struggled with in Australia, and I'll only deal with this fairly briefly given the time, is finding an adequate remedy. Okay, let's say that we've got those first three issues out of the way. Okay, let's say that uncertainty is not an issue. Let's say that if we did include good faith, the court's going to support it. Let's say that the court agrees that we've done the right thing on those first three issues. They get to the fourth thing, and here's a stumbling block. If a party breaches the term in a contract to perform, let's say, a mediation before going to court, how do we find a remedy that is going to adequately compensate the innocent party to the breach of the contract? Well, we have a number of rules that attach themselves to the awarding of damages. Let me deal with damages first, which is a pretty common sort of remedy for contracts. One of those issues is compensation. I'm pretty sure, I think I'm pretty much on safe ground here to say that the American idea of remedies in contract law are the same as Australia, and that is that the damages are only compensatory. You only get compensated for the value of the promise that has been breached between the parties. Well, how do we go about compensating somebody for breaching a dispute resolution clause in a contract? What value can we possibly put on that? How do we know whether, if the parties had proceeded with the dispute resolution process, that they would have been successful and therefore avoided court? How do we come up with some sort of monetary figure that adequately compensates the parties for breaching the dispute resolution clause? That's a big problem. A big problem. The other big problem is we have a rule, again, maybe the same here in the States, that a plaintiff must mitigate their damages. They mustn't allow the damages to blow out. They must do what's within their power reasonably to contain those damages. Let me paint a little picture for you. What happened? Let's say that you and I are in dispute. And let's just say that I'm an absolute ratbag who wants his day in court desperately, for whatever reason. Let's say I've got deep pockets. I want my day in court. You know that if we go to mediation, it's going to be a waste of time. It's just going to be a waste of time. I am not going to agree to anything you put up because I want my day in court. Aren't you mitigating your loss by saying, let's not go to mediation? Because all going to mediation is going to do is add cost and time onto the ultimate damages that will be payable for the breach of contract. Aren't you mitigating your damages by doing that? mitigating your loss by doing that? Well, yeah, you probably are. So in other words, you're saying, let's breach the dispute resolution clause because the other side is never going to agree in a dispute resolution process, and therefore we are containing the costs associated with the dispute. So that's the other big problem we have in Australia, is how do we overcome this mitigation of loss issue. The other thing that goes hand in hand with this is, well, what kind of damages? Let's say that you did find that there were damages payable. Well, what kind of damages would you pay? And again, without boring with the details, given the time, I can say to you that in Australia, we've had a number of judges and commentators say that probably the only thing you're going to get are nominal damages. You're not going to get any other head of damages because, again, we don't know whether the dispute resolution process would have been successful if you'd embarked upon it. And therefore, we can't ascribe any other head of damages. The best you're going to get out of this particular breach of contract is nominal damages, those sorts of damages that effectively give the other party a slap on the wrist and say, well, you shouldn't have done that. Here's a token amount to the other side. That's the best that we can come up with. The other popular remedy in contract law is an order for specific performance. Again, I think pretty much the same here in the States. So, in Australia, this is an equitable order that is at the discretion of the judge. And again, there are a number of rules that surround themselves about a court ordering specific performance. I haven't got time to go through all of them, but there's one that is a real stumbling block for our courts in relation to enforcing dispute resolution clauses, and that is the fact that the court doesn't want to get caught up in supervising the order for specific performance. The court is very, very concerned that if we send the parties out of the courtroom to specifically perform the terms of the contract, they're going to be constantly coming back to us saying, well, the mediator says we should have an adjournment, Judge. What do you think about that? Should we do that, do you think? Or the old apportionment of costs. We haven't agreed on the apportionment of costs or even the fee for the mediator. Judge, can you tell us what that should be? So the judge is terribly concerned, the courts are terribly concerned, that if we send the parties out of the court and force them to perform the dispute resolution clause, that they are constantly going to be back in front of us seeking directions on how to perform performance. And that is a monumental problem for some of our judges in Australia. All right, well, given the hour, I was told to leave a few minutes for questions. Those are the four problems. Those are the four problems that we have. The first one's easy to overcome. The other three we have yet to overcome. I think we can overcome them, particularly this issue of certainty. We can overcome them by, annexing processes to the back of contracts, those sorts of things. Avoiding good faith, references to good faith negotiation, that's an easy one to solve problem number 3. Finding a remedy is a little bit more challenging, but again, we know that in contracts we can agree on a figure for a remedy should one party breach the dispute resolution clause. So I think we can overcome that problem as well. Have we overcome it? No, not yet. There is some very, very clever drafting going on in contracts at the moment in Australia that seek to address these issues, and once again, we look for a decision, particularly in the High Court of Australia, that will ultimately say, yes, providing it's drafted with the requisite certainty, we will enforce the dispute resolution clause. Any questions? Yeah.
Jurisdictional question. The statute that requires good faith, what statute is that? What jurisdictions?
It's the Civil Procedure Act in New South Wales. Every jurisdiction in Australia stood up and took notice when there was a landmark report by the English judicial system on how civil procedure should unfold, and we're in the process of implementing that report. And the Civil Procedure Act is a 2005 Act of New South Wales that's being replicated largely around the country. So you'll find just about in every jurisdiction, ultimately there will be a good faith requirement on court-annexed dispute resolution processes.
It seems like one of the rationales for enforcing a lot of these dispute resolution clauses and whatnot here. It's just the load that is on the court, the amount of litigation the court has to deal with. Here, they try to push out. I mean, there's a lot of. What is the caseload like in Australia, and is one of the issues maybe you just need to get to a point where courts want to enforce these because they're too busy otherwise? I mean, do you know what the comparative loads of the court are? How busy are they?
Yep, it's much the same. Part of the reason that all of this has started to happen, in particular the Court and X programs, is because of that. Too many cases. I mean, when I was practicing as an attorney 15 years ago, it would take you about 5 years to get your case heard in the Supreme Court. And of course the costs are just enormous. About $100,000 for 3 days in the Supreme Court is a conservative estimate of costs to your client. So yeah, the courts had a decision. Well, we can either build more courthouses and employ more judges, and that's a very expensive option. Or we can embrace this thing called dispute resolution and try and flick as many matters out as we can. But there is still a bit of resistance. I've been saying to Jean, she's not quite convinced yet, I don't think, but we're probably 10 years behind the United States in that respect. There's still quite a bit of resistance on the bench as to the usefulness of it. But certainly the politicians are very, very keen. In fact, we've had an Attorney General in Victoria about 18 months ago start the process of employing judicial mediators. So you walk into a court and there's two signs, come here for litigation, or we've got a judge waiting to mediate the case for you as well. So that's a pretty radical move for us. So yeah, it's being driven by economics, there's no doubt about it, but we're still fighting the fight, I suppose. Yeah.
While you've talked about enforcement, from your perspective, do you find that the parties, as a contractor, for instance, and owners, have come to embrace this concept and are in fact using it, or are they getting talked into skipping it and going on to the more expensive, relatively lose-lose proposition going to litigation that's trying to find a win-win proposition in ADR?
Yeah, look, I think that's why some of the judges have taken this backdoor approach, the stay of proceedings approach, because the parties are positive about using dispute resolution to avoid arbitration and litigation. Arbitration is on the decline in Australia big time because of the cost and the time it takes to initiate it. So the parties are very pro-dispute resolution and gladly put these clauses, or allow their lawyers to put the clauses in the contracts. Going hand in hand with that is I guess, an English common law principle that our judges really do adhere to, and it came from a very, very old case, Hillis against Arcos. It should be about 200 or 300 years old, I think. And it basically set up the proposition that the courts won't be the destroyers of bargains. If you agree to participate in the dispute resolution process, then as a judge, I ought to uphold that promise. And unless there's a very good reason, such as uncertainty as to the process, then I ought to send you out of the courtroom and make you do what you promised to do. So most of the judges, particularly the common law judges, are really quite attuned to that particular concept. So, they want to, but they're also thinking, well, hang on a minute, that's our business. We've got lawyers, that are employed, standing in front of us saying, what do we do? Well, maybe if the clause isn't so certain, we can just knock it out and get the case brought on. Certainly in the district court, the middle level in the state court structure, they're now only putting what they call complex cases that run or estimated to run 5 days or more of trial. They're automatically putting those into mediation, automatically, to try and relieve the backlog and the cost that the cases are costing the taxpayers of Australia. But it's still a balancing act. It's still a balancing act. I mean, there are judges still coming onto the bench, and most of our judges are taken from the senior levels of, we have a split profession in Australia, barristers and solicitors. And they're mainly the barristers are the court advocates. And they're mainly taken from the senior ranks of barristers, those that are Queen's Counsel or what we now call Senior Counsel. And so these are people that have spent their life litigating. That's all they know. They're litigators. They go onto the bench, and of course, what do? They kind of take the view that, well, litigation is the answer. but we are gradually educating. Most of these judges now have compulsory education, not only in dispute resolution, but other matters of importance, such as gender equality and all that sort of thing. So we're getting there. And most law students now coming out of law schools will have a dispute resolution course under their belt, whether it's compulsory or elective. So it's a culture change, and it's going to take years to, finally work its way through. But we're getting there. We're getting there, slowly but surely.
To the point of information and an observation, in the family court here, for instance, in the district family court, they have mandatory mediation on custody issues, for instance, and also they have case conference reports where both parties have to narrow the issues before they go to trial. There's no requirement of a good faith negotiation, whatever it means. But just reflecting on it, it could be possible for the judge to find that a reasonable lawyer would have narrowed the issues and therefore award attorney's fees against the other side if they prolonged the litigation by not narrowing the issues. So that could be a way of trying to monetize the cost of litigation.
Yeah, we've only just in the last 12 or 18 months moved to mandatory mediation in the family court in Australia, and that's a very, very big move. Again, it's not being greeted terribly well by senior members of the profession because they've lost a lot of business. So, for example, let me just give you one great example, I think. The week before I came here to the United States, not because I thought anything was going to happen, but it was one of those trigger mechanisms. I thought, gee, I haven't updated my will for about 10 or 15 years. So I went to see my local attorney and a friend of mine and got him to update my will. Now, this guy deals mainly in family law, property law, and wills and succession. And I said to him, Robert, are you still practicing family law? And he said, well, I was getting 20 matters a week prior to these changes in the family court that now require mediation. He said, I'm lucky if I get one matter a week. They are knocking these family court matters out of the court system like you wouldn't believe.
Yeah, just do a good job.
Well, yeah. And in fact, there are organisations like Relationships Australia that are doing very well, thank you very much, out of running accredited courses and accredited mediators for use in the family court system. Yeah, they're doing pretty well.
I think it's the last question. When you were talking about the good faith issue and trying to figure it out, has anybody simply proposed that good faith and self-interest, that it may be in one's self-interest to try to reach a dispute that both sides amicably are to? I mean, they have this confrontational view. You can't be self-interested and have good faith, but can't one simply argue that part of self-interest may be to look for some kind of middle ground for both parties, and therefore?
Yeah, I think that's a very, very elegant argument. But of course, you don't want to take it too far because then you may be getting into the territory of, well, that means you need to be making concessions. That means you may be needing to think about settling, and that's very much not what good faith is about. You should still have the right to preserve your self-interest, providing you've acted in good faith. But it's a very elegant thought. You're right. The argument holds true that it is in your self-interest to try and negotiate these matters out through mediation, conciliation, or negotiation before you jump in.
Thank you so much.
really important step in gathering evidence to be able to do that. Because, we all know the truth of the That's Australia as well. In fact, there was a ask about street I think the reason they just didn't ask. But certainly,
Hey there.
Are you going to be handed a law school for?
just this week.
Right.
It's been a long time. It's an amazing piece of architecture.
I'll return.
I think that, I don't think it's sort of different from the US. I think